Good morning, everybody. Welcome to our webinar this morning. We're just going to give it a minute or so whilst the numbers come in. We've got quite a few people signed up to this webinar this morning, so we'll give it probably till about just a minute or so past 9 to make sure everybody's coming. One would hope Zoom had fixed this by now, but I'm told it's still something we have to do, so just bear with us whilst Helen and I are on screen here, ready and waiting to speak to you. Helen go to far more effort than me in my home office as she's ready to sit for a day of judging. So we're getting an insight into a district judge's room right now as well.
As a part-timer, I'm not at liberty to start rearranging furniture, so you have to forgive my background, I'm afraid.
That's okay. We can't see any details. It's just the insight. Are you able to tell us where you're sitting today, Helen?
I'm in Bradford Combined Court Centre.
Oh, I quite like that. There's good parking.
Good parking, good cafe. Would recommend.
I mean, you're absolutely sorted then. As Fridays go, this is a good one. Okay, well, we've got to 1 minute past 9. I'm afraid I can't actually see. Can I see? Oh no, it looks like our numbers are steady now. Maybe we're getting a few more in, but hopefully people will understand. Unfortunately, that's just the way it seems to work with Zoom. So we will get started. So good morning. My name is Laura Gould, and I'm here with Helen Gardiner today, and we're going to be talking to you about restrictive covenants and confidential information. And we're going to be giving you some practical tips and recent updates. Helen and I are both barristers at King's Chambers, and we're both in the business and property team, or what we used to call Chancery Commercial, and the employment law team. So this is an area of the law and practice that really intersects between our two practice areas. So we hope to be able to give you some useful practical insights, as I say, in addition to covering the law more generally and a few updates. Helen's going to talk to you about restrictive covenants, and then I'll come on to talk to you about confidential information. We've got some practical tips at the end. We do have, I can see here, so it's a Q&A function. If I could ask people, if you've got any questions, to put them in the Q&A function. It might be that as one of us is speaking, the other one's able to reply in there. We're aiming to have some time for questions at the end, but as with all seminars, can't promise, I'm afraid, and appreciate we've only got an hour of your precious time on this Friday morning. But if we're not able to respond during this seminar, or webinar, I think I meant to call it, then I think we do get a record of those, so we'll try and follow up with you afterwards. Obviously, you can post anonymously, I think, but if you put your name in there, we'll be able to see your contact details, I think, from the sign-up sheet, and we can try and respond there as well. So thank you very much for joining us this morning, and I will hand over to Helen.
Thanks, Laura. Before I start, I'm just going to let you all know there is quite a detailed handout that accompanies this talk. That's going to be sent out next week along with a recording of this webinar. So please grab a coffee, put your feet up, don't feel that you need to be scribbling notes, because you'll get much of what we're saying in the notes that accompany. So bear with me while I try and share my screen, and we'll make a start. All right, can I just check? Laura, can you see the slides? I can see your face. I can't see anybody else.
Yeah, I absolutely can.
Lovely. All right. So we're here to talk about, obviously said, restrictive covenants and confidential information. This all arises from the principle of restraint of trade. And the key principles, they'll be really familiar to you, I've no doubt. But the starting point is any restriction in restraint of trade is void. Save insofar as the employer establishes that there's a legitimate business interest capable of protection, and that the covenant is no wider than is reasonably necessary to protect the business interests. Lovely picture of Mr. Justice Haddon Cave for you there. A helpful case on this is QBE UK Limited versus Dimmock, and you'll see that I refer to that quite a few times throughout the talk. The court's general approach to restrictive covenants was set out in that case at paragraph 210. And what Judge Haddon Cave said was that it's for the court to determine what the covenant means, properly construed. The court then needs to consider whether the former employee has shown on, the former employer has shown on the evidence that it has the legitimate interest requiring protection. And once legitimate protectable interests are shown, the covenant must then be shown by the former employer to be no wider than reasonably necessary. So far, so good. But he said that even if the covenant is held to be reasonable, the court will decide whether, as a matter of discretion, injunctive relief should be, in all the circumstances, granted, and bearing in mind all of the circumstances, including its reasonableness at the time of trial. The burden is on the covenantee, so the employer, to establish that the restraint's no greater than reasonably necessary. And he made it clear that reasonable necessity is assessed from the perspective of reasonable people in the position of the parties at the time that the contract was entered into or varied. And we'll come back to that point shortly. So in relation to construction of covenants, contractual issues, so the usual principles of construction of contracts apply. Words should be given their ordinary meaning. We all know that from ICS and West Bromwich. The court is, when construing a covenant, seeking to identify the objective meaning of the words used, taking into account the factual matrix against which they were contracted, and with their stated purpose in mind. And in these cases, that's going to be the protection of the employer against unfair competition. And so, as Turner makes clear, the courts will adopt a purpose of construction. Where the wording is ambiguous and there is one possibility that renders the contract valid and one realistic alternative which would render it void, the preference will be for the valid construction. And just nipping back to that point about reasonableness at the time of contract, that was covered in the case of Pat Systems and Neely. But you look at what the circumstances were at the point when the parties were entered into, so usually when the employment started, or if there have been any variations along the way. Unless there have been fresh covenants with fresh consideration, then you could have a situation in which somebody who, at the end of a very long period of employment, 20, 30 years, is an extremely senior employee who, at that point in time, the covenants might be appropriate in relation to, but who started right at the bottom of the ladder. And when they started, the covenants were wider than reasonably necessary. And it's so one looks at when the contract started, not when it finished. The most recent development of the law on restrictive covenants comes in relation to the principle of severability, what's known as the blue pencil test. So courts won't rewrite contracts, but they will allow, in certain circumstances, for offending words to be cut out of the contract. That was looked at by the Supreme Court in the case of Tillman versus Egon Zender. This case is definitely worth a read. It sets out in a great degree of detail the evolution of the law on the restraint of trade. The case itself concerned a very senior employee who'd gone to work for a competitor within a 6-month period, apparently covered by a restrictive covenant. She did that openly. She told her employer that her previous employer that she was going to do it. The covenant in question provided that she wouldn't be directly engaged or be concerned or interested in any business carried on in competition with her employer. And Ms. Tillman argued that the phrase "or interested" prevented her from holding any shares at all in a competitor's business. And that was too wide. The Supreme Court agreed with her and said that "or interested" meant a shareholding of any size, majority or minority. But they went on to permit the offending words to be excised so that injunctive relief preventing Ms. Tillman from taking up the employment with the competitor in that restricted period was upheld. And what was set out after a long review of all of the relevant case law was this 3-stage test that we see in Tillman. So the first is that the unenforceable provision has to be capable of being removed without the need to add to or modify the words that remain. Then the remaining terms must continue to be supported by adequate consideration. That's usually not going to be contentious at all in the kind of cases we're talking about. And then this is what was called the crucial criterion. The removal of the provisional wording must not generate any major change in the overall effect of all the post-employment restraints in the contract. What the Supreme Court stressed was that the focus has to be on the legal effects of the restraints, not on the ever-changing factual effects of the restraints. And the burden here is on the employer to satisfy the court. But whilst this has clarified what the test for severance is, a few things do arise out of it. At paragraph 82, Lord Wilson gave a warning about the use of severance to uphold otherwise invalid contracts. And what he said is this: it's clearly common practice for an employer to present a prospective employee with a substantial written contract, many terms of which, including those imposing post-employment restraints, are derived from books of precedent. It is as valid in 2019 as it was in 1913 to infer that most prospective employees will not be able, even if minded, to decline to accept such terms, still less, following the end of their employment, to defend a claim that they are in breach of them. And he said, the courts must continue to adopt a cautious approach to the severance of post-employment restraints. This isn't on the slide, but for a recent example of where severance did operate to uphold an otherwise invalid non-compete clause, in a case from this year, Boydell versus NZP Limited, but that's contained in the notes, so I'd refer you to those in due course. This wasn't explicitly set out in Tillman, it was implied, but there may very well be cost consequences for the employer, even if they are successful following an argument on severance. So do bear that in mind if you are resorting to severance to fix a contract. Lord Wilson said that the employer in the Tillman case may experience a, quote, sting in the tail when it comes to costs. And he talked about severance being an exercise of tidying up what he called legal litter, referring to the Fresh Asia case, which is in the notes. You can, of course, this is often seen in contracts, include an express blue pencil clause, which says that where any offending part of the contract is void, then the rest remains valid. Those express clauses don't really add very much to what the court would do anyway under the common law. There are some cases where there have been more extravagant clauses where the parties, for example, agree to reduce the period or otherwise relax the restrictions so that they are valid. They unfortunately don't work. Those are effectively agreements to agree, and they offend against the principle of contractual certainty, which is discussed in the case of Walford and Miles. However, in theory, a clause could seek to impose a restraint for such period on such terms as the employer reasonably directs. That gets around the Walford and Miles problem because there wouldn't be an agreement to agree. However, following the Braganza case, if there is such a clause, and they're not common, the court would impose a duty of good faith on the employer that would be tested against public law principles. Having said that, though, my view is that since all covenants are in restrictive trade are prima facie void, the court might very well conclude that a clause seeking to bestow that kind of power on the employer necessarily provides greater protection than reasonably required. So I think they are risky. If you're drafting contracts, I would avoid those. So let's move on to what are the recognisable protectable interests. There are three usual justifications: protection of customer connections, protection of confidential information, and the stability of the workforce. Although it is clear from case law that the category of protectable interest isn't closed, although other ones don't come up very often, and I'm not aware of any case law. Recitals. This is a point of practice. A well-drafted contract may very well include a recital which identifies the particular interest that the employer is trying to protect. And where they do that, that will be taken into consideration by the court when construing the contract, because it clearly sets out the contractual purpose. Do beware, though, when drafting any recitals, to make sure it covers any and all protectable interests, because the Office Angels and Rayner case told us that where there is a recital, the employer can't then seek to justify a covenant on the basis of a separate interest that hasn't been identified. It's fairly obvious to say, I think, but the protectable interest still has to persist at the time that relief is sought. So, for example, an injunction won't be granted to protect competition in the market where the employer no longer trades. And the Beckett case, just as a point of interest, tells us that legitimate business interests of group companies can, in certain circumstances, be protected. So let's talk about customer connections first. There are 4 main ways of protecting customer connections, and we'll talk about each of them. Excuse me. So the first is non-solicitation. These are fairly common, and they can be critical to the protection of customer connections, protecting the goodwill of the business. Where they are reasonably drawn, they're likely to be enforceable. So what does reasonableness look like? Well, all sorts of factors will be taken into consideration, but the nature of the business. So is the business dependent on repeat business from an identifiable body of customers or clients? The more you lean towards that, the more likely the clause is going to be enforceable. What's the role of the employee in question? How senior were they? Was their role customer facing? If they are senior, they may very well have customer connections on a personal level, and a covenant be more likely to be enforceable. Equally, if they're customer facing, if they're the face of the company even, is more likely to be enforceable rather than somebody who plays a back office role. That's more likely to come into the confidentiality arena. And here, with the role of the employee, what the court's going to be looking at is how it's said that the employee has obtained some unfair advantage by breaching the non-solicitation clause. The court's going to be very interested in the definition of clients in any covenant of this nature. So is the definition restricted to those actual and potential clients that the employee dealt with? That's more defensible than a restriction against anyone who has done business with the company for a certain period, whether or not the employee has actually met them or dealt with them. And also, how far back does the clause look? If it's, it will depend on the nature of the business. How frequently are orders placed? Are they weekly, monthly, quarterly, yearly? And that's going to feed into the reasonableness. And finally, how long is the employee going to be prevented from dealing with these clients? And it's obvious to say it, but the longer the time period, the more difficult it is to justify. What, in fact, is a breach of a non-solicitation clause? There's some case law on this, some of it dating back to the 19th century. It's clear that non-solicitation prevents a specific and direct appeal for the customer's business. Mr. Justice Haddon Cave in Dimmock told us that canvass is synonymous with soliciting, and he said both words involve an approach to customers with a view to appropriating the customer's business or custom. And he said that a degree of influence is required. There has to be an active component and a positive intention. On the flip side of that coin, in the Baldwin's case, he's on Judge Simon Brown QC said that a general advertisement to the world about availability for customer to new firm or a specific notification to a client of departure does not cross the borderline, but any activity or behaviour beyond that would. An example that's often seen in my experience is hairdressers. So a hairdresser might tell their client, I'm leaving this salon and I'm moving to another salon. That on the Baldwin's assessment wouldn't be soliciting. If she said, or he said, I'm leaving this salon, I'm moving to the next one, here's my number, next appointment, come and book in with me, that then would cross the line into soliciting. Non-solicitation clauses aren't always the most effective for a number of reasons. First off, there is difficulty with proving a breach. It requires evidence as to how the former employee came to do business with the prohibited client. And whilst you might be able to glean that from emails or phone messages that are picked up during towards the end of the employment, in reality, you're likely to be reliant on the client telling you how it is that they come to do business. And unsurprisingly, clients don't want to get embroiled in this kind of litigation. There's also the real risk, and again, hairdressers is a good example, where the former employee has such a strong influence over clients that the clients follow them anyway, whether they've solicited or not. So a non-solicitation clause might not be the best option to protect the business interests. And it's for that reason that courts tend to look more favourably on, or favourably, not more favourably, on a reasonably drawn non-dealing covenant, which simply says that rather than not soliciting, that the former employee cannot deal with, for a certain period of time or within a certain territory, certain customers. Many of the same considerations apply, although it's arguable that less protection is justified on a non-dealing basis, given that it's so comprehensive. Area covenants, they're pretty much out of fashion now. They are entirely arbitrary. They impose a blanket ban on a restricted business within the defined area. And so they would prevent the former employee from doing business with clients who had never heard of them, let alone done business with the employer, simply by definition of their postcode. Also, they're not necessarily effective, particularly in what's now more of a global economy, because they give no protection outside the area, even respect of business with a major customer. It was discussed in Office Angels and Rayner Thomas that an area covenant will always be approached with caution, and they said they've had their day, these covenants, but they are generally regarded as inappropriate, save in cash businesses where there's a loyal following of clients who aren't readily identifiable. But think carefully before drafting an area covenant into any contract. Bare non-competition covenants are the most difficult to justify. They are case specific. I'm not saying they will never be justified, and Thomas and Farr tells us that they can be defensible in certain circumstances. For example, where there is a very senior executive who has access to all of the company's confidential information and who is effectively the face of the company. And so whatever other protection was in place, it wouldn't be enough to protect the legitimate business interest. But it really is a high bar for their non-competition clause. And if these are appearing in contracts for anybody less than a very senior employee, they're likely to be the subject of challenge. Having said that, pure non-competition clauses are more justifiable when you look at business sale agreements. As set out in Traeger and Hunt, it's not an honest thing to pocket the price and then to recapture the subject of sale. And there's another nice analogy given in Tillman, quoted in Tillman, that you can't sell the cow and then drink the milk. So I'm now going to hand over to Laura, and we're going to look at confidentiality.
Thank you very much for that, Helen. And apologies to anyone if I have to just briefly mute. I'm afraid I'm suffering with a cold that probably half of you that are watching us are as well. But I'll do my best to make sure you don't have to hear me cough at all. So apologies. And for the potential inevitable Chris Whitty style next slide, please, as Helen still has control. So yes, of course, this is often a overlapping issue that arises in the source of work that Helen's been talking about in terms of confidentiality. So a good starting point here is the decision of Lord Neuberger in the Vestergaard case, which is, well, I say relatively recent, 10 years ago now, but looking at the fair balance between protecting trade secrets and not unreasonably inhibiting competition. What Lord Neuberger there said in paragraph 44 was that the law has to maintain a realistic and fair balance between, one, effectively protecting trade secrets, and I emphasize that as you'll come on to see why, and many of you will know already, and other intellectual property rights, and two, not unreasonably inhibiting competition in the marketplace. And he commented that the importance to the economic prosperity of the country of research and development in the commercial world is self-evident, and the protection of trade secrets is one of vital contributions of the law to that end. On the other hand, the law should not discourage former employees from benefiting society and advancing themselves by imposing unfair potential difficulties on their honest attempts to compete with their former employers. Well, all sounds very fair, all sounds like a good description to allow there to continue to be work for lawyers in this area as to what that's going to mean, in what situation, and particularly when technology, etc., is changing so much, and it's often ends up being the lawyers bringing things to the judiciary and trying to get everybody up to speed on what that's actually going to mean. So if I can have the next slide, please, Judge. Okay, so looking first of all at implied terms, and one might think, well, if we're talking about contractual terms, why wouldn't you go express and then implied? And it's because actually we often see cases where one has to rely on implied terms in respect to confidentiality because nobody thought we'd end up in this position. Nobody thought this would ever happen. And so there aren't actually express terms in the contract. And Helen's already mentioned our diet of hairdresser cases. And this is a good example from one that I had that went all the way to trial, where it was very much a Robin Green type case. So it's well established, of course, that it's breach of an employee's duty of fidelity to make or copy lists of the employer's customers, or to deliberately memorize such lists. I'd be terrible at that, for use after employment ends. And so there, the easy example, as I say, hairdresser lists. Interesting one, because of course in the past you might have to have recorded not only the name but the phone number, whereas now it could be, you know, the name, maybe you are already friends with them on social media, which will create some different set of circumstances. But if you can go and find them on social media, find them on LinkedIn, it's perhaps easier to identify people than it used to be on what is it you've committed to memory if you just remember their face and their name. But that's certainly the starting point for the principle. And then in terms of the breach of the duty of fidelity, if it allows the former employee to obtain an unfair competitive advantage, that could, of course, lead to a claim for springboard relief. And that's something that Helen's touched upon already. So if we move on to the next slide, we'll take a deeper dive into this, as they say. I'm sure many of you will be familiar with the gender chicken and Fowler case. And again, that's very much the starting point in terms of the implied duty of fidelity, which was considered there by Goulding J. There, the judge distinguished between three classes of information, and we've numbered them in the order they were given there. So class one, which we've just said there, trivial, So information which, because of its trivial character or its easy accessibility from public sources of information, cannot be regarded by reasonable persons or by the law as confidential at all. And there's no restriction on the disclosure of this information, whether during or after employment. Class 2, let's have a good debate about this. Information which the servant must treat as confidential, either because he's expressly told it's confidential or because from its character, it obviously is so, but which once learned necessarily remains in the servant's head and becomes part of his own skill and knowledge applied in the course of his master's business. This information is only protected during employment. And then class 3, specific trade secrets, so confidential that even though they may necessarily have been learned by heart and even thought by, and even though the servant may have left the service, they cannot lawfully be used for anyone's benefit but the master's. And there, it's obvious from what's said in the decision, the employee cannot use such information even after employment. So let's go on to have a look at, in a bit more detail at trade secrets. So that's a term, again, it sounds in the time in which it was first referred to, and perhaps wouldn't be exactly the sort of term that we might use now if we were describing what's been called trade secrets. Clearly, it's an apt term to describe secret processes of manufacture. But actually, class 3 and what's called specific trade secrets is far wider than that. Mr. Justice Cross, who I assume that is a picture of, thank you very much, Helen, for the pictures, dealt with this in Printers and Finishers Limited and Holloway, and you can see that's a 1965 case, so we're going back some time here, I suppose as we were with Robin Green going back all the way to the 1800s. But there he said, if the information in question can fairly be regarded as a separate part of the employee's stock of knowledge, which a man of ordinary honesty and intelligence would recognise to be the property of his old employer and not his own to do as he likes with, then the court, if it thinks there is a danger in the information being used or disclosed by the ex-employee to the detriment of the old employer, will do what it can to prevent that result by granting an injunction. Thus, an ex-employee will be restrained from using or disclosing a chemical formula or a list of customers which he has committed to memory. Again, thanks to Mr. Justice Cross for being so clear and using such clear language, but thanks also for creating a test there which allows lawyers to argue around what that actually means. We're talking, man on the Clapham omnibus, if it looks like a trade secret and it quacks like a trade secret, it's probably a trade secret. But as to one person's interpretation and another's in particular set of circumstances, very much open to debate in a number of situations. On appeal in the Fish End Chicken case, Lord Justice Neal explained that the implied term extended to information which can properly be classed as a trade secret or as material which, while not properly to be described as a trade secret, is in all the circumstances of such a highly confidential nature as to require the same protection as a trade secret. A gloss on what has already been said, I suppose, but again, still allows for that area of debate, I would suggest. And I think that's why we've got so many people listening in today, because so many of these areas do allow for debate. Again, a further attempt was taken to define a trade secret here by Lord Justice Staunton in the Lansing, Lind and Kerr case. And we made it all the way to 1991 by this point. And not to do too much of an academic or history lesson, but it is worth working through these points. And the quotes I'm giving you will be in the handout we'll give to you. And it's helpful not to just look at the more recent case law, but to work through these quotes to see the development and try and understand what the court was trying to define and why it's not necessarily all that easy to do so. So there he said, trade secrets are information which, if disclosed to a competitor, would be liable to cause real or significant harm to the owner of the secret. I would add first that it must be information used in a trade or business, and secondly, that the owner must limit its dissemination of it, or at least not encourage or permit its widespread publication. So Again, we're talking there about evidence in terms of real or significant harm, it being used in a trade or business, but also that the owner was already trying to limit or not encourage it being spread or published. And that's another matter where you could have conflicting evidence. And it might be the sort of matter where you're having, again, social media evidence as to what was being discussed, what was being referred to, who did a TikTok on what about their new developments, etc., to be able to argue around that point. And Lord Justice Staunton held that, contrary to ordinary parlance, trade secrets might therefore include the names of customers and the goods which they buy, which, fair enough, if one were talking trade secrets, I don't think the ordinary person would ordinarily think of that as such. Just moving on from here to the next slide, we've got the Mr. Justice Tugendhat from the case of Caterpillar and Huesca de Creen, where he observed at paragraph 37 that it's not a debate about the meaning of words. And in particular, he said, the debate about what is or is not a trade secret, or what is or is not confidential information which an employer may protect, is not a debate about the meaning of words, as would be the case if it were in statute. It is a debate as to what words to use in order to give effect to the competing public interests that are relevant where a former employee is asking for an injunction to restrain a former employer is asking for an injunction to restrain a former employee from working for a new employer or for himself. And that's again why I say it is worth working through the brief history of this area of law that I'm setting out here and that you'll get in the notes, in order to understand what are the competing public interests and how ought they to be balanced, or as youth of today might say, vibes. What are the vibes here, and where do you then say, as an advocate and as a lawyer preparing this case, why it ought to fall down on one side or another? So that's dealing with implied terms, but what about express terms? And I'm sure many of you will be thinking of ones that you've seen, that you've drafted, that you've argued about. There are two distinct types of express contractual provision imposed to protect confidential information. So you can have restrictive covenants. The preservation of confidential information is, of course, one potential justification for covenants being imposed on the employee's ability to compete or deal with or solicit employers' clients. So it is something that can be captured, and that follows on from the cases that we've looked at already, and we'll come on to look at a couple more in detail, such as the Littlewood's case there. And then confidentiality clauses. And of course, in many cases, there are express confidentiality clauses requiring the employee not to use or disclose information. So in terms of restrictive covenants, coming back to the tender chicken case, Mr. Justice Goulding suggested that class 2 information, which, if you'll recall, we summarised as mere confidential information, could be protected by a restrictive covenant, restraining the employee from competing within reasonable limits of time and space. So you'd have to weave this in with what you've heard Helen talk about already in terms of those reasonable limits. The Court of Appeal appeared to disagree, holding that only a trade secret or its equivalent could be protected. And there it's worth looking at what Lord Justice Neal said. And he was citing with approval the decision from Mr. Justice Cross in the printers and finishers case that we've looked at already. Again, shows why we do need to link all of these through. And there it was said, and this is the comment from printers and finishers, if the managing director is right in thinking that there are features in the plaintiff's process which can fairly be regarded as trade secrets and which their employees will inevitably carry away with them in their heads, then the proper way for the plaintiffs to protect themselves would be by exacting covenants from their employees, restricting their field of activity after they have left their employment, not by asking the court to extend the general equitable doctrine to prevent breaking confidence beyond all reasonable bounds. And I would suggest it's a dictum that's responding to a particular set of circumstances there, where it's saying, don't leave this up to the court to do, go and protect these interests yourself. But of course, if you have protected those interests yourself, that's not to say that they will necessarily be upheld, or that it couldn't just be said, well, weren't you sufficiently protected by what you had at common law anyway? And really, the sort of protection that's being referred to there wouldn't really be necessary, because it's talking about trade secrets, and we know that they're protected, as we've looked at already, regardless of whether there's any express covenant. So it doesn't really seem to take matters further, and that's why I say it's arguably looking at the very particular circumstances there, and you may all be thinking, well, hang on, that's not how I thought things worked. So whilst Vicenza Chicken envisaged a very limited role for express covenants, there have been decisions since which have confirmed that suitable express covenants can sometimes protect mere confidential information. So in the Balston Limited and Headline Filters case, and this is from 1987, there Mr. Justice Scott also had some reservations about Vicenza Chicken, and if it meant that express covenants could never protect Category 2 information. He avoided the problem by declining to interpret Lord Justice Neal's decision in this way, pointing to the reliance on the Cross-J printers and finishers case. And so it was one where it doesn't decide it, but it shows how it can be gotten around. Then in another case, I don't think we've got it on the screen here, but you'll have it in the slides, the case of Lancashire Fires Limited against SA Lyons & Co., which is a 1996 case. And there, Lord Bingham, Master of the Rolls as he then was, suggested that the Court of Appeal had been wrong to identify any difference between the reasoning of Gould and J for Vicenza Chicken and Cross-J's dictum. So essentially saying, no, Gould and J was able to say what he did already in terms of the protection of the Class 2 information, and that was actually consistent with what Cross-J had said previously, whereas the Court of Appeal interpreted that differently. So that's a particularly useful one for showing you the route around if you're trying to protect Class 2 information with express provisions. Really, real protection is often only actually obtained by way of restrictive covenants, and there it's worth looking at the Littlewoods organisation against Harris case, and that was the case of Lord Denning from 1977, where he observed, it is thus established that an employer can stipulate for protection against having his confidential information passed on to a rival in trade, but experience has shown that it is not satisfactory to simply have a covenant against disclosing confidential information. The reason is because it is so difficult to draw the line between information which is confidential and information which is not, and it's very difficult to prove a breach when the information is of such a character the servant can carry it away in his head. The difficulties are such that the only practicable solution is to take a covenant from the servant by which he is not going to go and work for a rival trade. And that comes back to what Helen was saying before in terms of recitals and setting out your position, and it's a double-edged sword there because you've then got to get it right. But often in these cases, but anything we're talking about today, an employer having actually applied their mind to not only what they want, but why they want it in advance, gives far greater protection than seeking to justify it after the event on the basis of standard covenants that they might have included. All well and good for me to say that at the sharp end of litigation, but of course many of you watching this morning will be involved in drafting those sorts of contracts and clauses, and obviously they can be useful ones to refresh a position if someone gets promoted, if there's a change in their contract generally, so long as there's consideration. If you're spotting then, okay, we don't have the sort of detail that we think we've heard would be useful and that we ought to, it's obviously a point at which you can be advising and saying maybe we should be increasing matters in terms of specifics and protecting the positions here. So what about express confidentiality clauses? Confidentiality clauses do not seek to prevent any future employment or any solicitation of or dealing with customers, but impose express contractual obligations on the employee in respect of confidential information. And again, if one can say what that confidential information is and why it's confidential, more the better, as long as it's actually a properly considered and justifiable position. Express confidentiality clauses can be useful in identifying an employer's particular attitude to different pieces of information. So in Vicenza Chicken, in listing the factors relevant to whether information is protected as a trade secret, Lord Justice Neal included whether the employer impressed upon the employee the confidentiality of the information. Thus, though an employer cannot prevent the use or disclosure merely by telling an employee that certain information is confidential, the attitude of the employer towards the information provides evidence which may assist in determining whether or not the information can be properly regarded as a trade secret. So if you remember when we were looking at class 2 information earlier, it was said there, just because you're told it's confidential information in passing, that's not enough. But the attitude that's taken here is being said, well, that shows you ought to have known it was confidential. Again, that's something that is all well and good for Helen and I to go and have a debate about in court and cross-examine people on and make submissions on. But if an employer recognises it as confidential, and either if something new is coming out, set something out in writing so there can't be a debate about what was said, put something in an email and make sure it goes to all the classes of employees that it needs to go to. Or if it's something so fundamental and known about in the business already, includes that in the contract as an example of confidential information, it's going to be far easier in pre-action correspondence to point to those pieces of information or those descriptions and say, there you go, that's how you knew. That clearly satisfies for gender check-in, and you're not going to have much luck in arguing about that at a hearing. Otherwise, again, that's right for us as advocates to have a go at from either side. Indeed, an express restriction on the use or disclosure of specific pieces of information may assist an employer in satisfying the Staunton test by showing its efforts to limit dissemination. And in a lot of these cases, of course, the learnings are from what needs to be put down in writing. And again, that can be clarified in writing. But you have the double-edged sword of, if you don't, what does that mean? An express clause could carry greater weight. So in the Campbell against Frisbee case, thanks again for the photos, Helen, back from 2002, their Lord Phillips, as Master of the Rolls, said, it's arguable that a duty of confidentiality that has been expressly assumed under a contract carries more weight when balanced against a restriction on the right of freedom of expression, that a duty of confidentiality that is not buttressed by an express agreement. But again, you've got to make sure that that's justified, explained, justifiable. But you've always got the implied term fallback if you don't have that. So really what that means is a well-crafted express clause might both assist in establishing the scope of information capable of protection and arguably bolster the employer's prospects of success. That said, real protection is often only obtained by way of restrictive covenant, and we'll look there at the Littlewoods case again. And again, Lord Denning, where he said, it is thus established that an employer can stipulate for protection against having his confidential information, having his confidential information passed on to a rival in trade, but experience to show it's not satisfactory. Apologies, I think I'm going over the same point again there. So really, that's why we say, think about it in advance, think about why you need this and what you need it for, and have that set down in detail. There are good reasons for the court's insistence on a focused application about this. First and foremost, it is essential that a defendant might know precisely what is prohibited. And of course, that's an area where you'll have arguments both pre-action and all the way through in terms of what did the employee know, what ought they to have known, and you'd much rather be arguing about what did they know than what should they have known. Again, coming back to my points about what's set down in writing. And it's worth there thinking about the Lawrence David Limited and Ashton case, where Lord Justice Balcombe said, I've always understood it to be a cardinal rule that any injunction must be capable of being framed with sufficient precision so as to enable a person injuncted to know what it is he is to be prevented from doing. After all, he is at risk of being committed for contempt if he breaks an order of the court. The inability of employers to define with any degree of precision what they sought to call confidential information or trade secrets militates against an injunction of this nature. And that really puts a lid on everything I've been saying, and also applies to the restrictive covenant points that Helen was talking about earlier. I know that doesn't make it any easier for us if people come to us when there's already a problem and they haven't applied their minds to it. But whenever you're getting the opportunity either to advise at a non-contentious stage or to say, well, okay, here are lessons learned for how we should do this better next time, then that paragraph 132 from the Lawrence, David and Ashton case is a really useful point. Probably isn't going to help if you give it in that legal language to an employer, but for you to set in your mind what's needed and why it's needed, and to be able to go and explain that in your advice back to the client. So accordingly, where employers seek to protect confidential information by way of injunction, as it was said in Thomas and Mould by Mr. Justice O'Connor, it is essential that they should make absolutely clear what it is they're seeking to protect. So even if you didn't have that already, when it comes to you drafting the application, pleading the case, you really, really need precision at that stage. And I think it's still not uncommon to see some quite broad brush statements being made about what the confidential information is you're seeking to protect and why. You need to be absolutely clear and you need to be precise. And it's one of the many situations where if you can't explain it in 5 instances of very specific confidential information, you're probably not going to improve it by putting it in 50 different ways or 50 different types, other than in the rarest of cases. And so think about being clear and how well you're going to get that across to the court for them to really understand very clearly straight away what it is and why that's an issue. Just touching upon stability of the workforce, and so non-poaching clauses, a slightly different point to what both of us have been talking about, but non-poaching clauses may be enforceable, and you can see this from the Dorney Day & Co Limited against the Alphen case, which is a 1998 case. Senior employees may well have considerable influence over the key members of the team, and thereby that can create a risk that the entire team might be stripped out. Although it's a more recent phenomenon, the common law does now recognise that the employer has a legitimate business interest in the stability of its workforce, and that in an appropriate case, a reasonably framed covenant against poaching of staff might be enforceable. So, as I say, that's seen in the Dorney Day case, and go back to the principles that Helen was talking about earlier and the ones that I flagged that would be sort of overarching and useful across the board on these sorts of points. Even where there's not an express term, the courts have been seen to be increasingly willing to grant springboard relief in team move cases. Of course, Dimmock that Helen's been talking about, along also with GD Searle and Caltech was an early case on these matters from 1982, and there Lord Justice Cumming Bruce observed that there was nothing in the general law to prevent a number of employees in concert deciding to leave their employer and set up in competition with him, and safe to say were a fair distance from that now in appropriate cases. And Mr. Justice Haddon Cave was talking about the direction of travel since Searle in the Dimmock case, in terms of preventing senior employees from poaching colleagues, even in the absence of a enforceable restraint. So that's one to have a look at the history of again. So just moving on to some practical considerations, I think Helen's coming back in here. Helen, I think we want to talk about overlapping up and current causes of action.
And then we'll talk about how this features in the Employment Tribunal as well. In terms of concurrent causes of action, it's not uncommon in these kind of cases to see a number of defendants named. So you might have, for example, the employee who was left and has he's set up in competition, he's used confidential information, or he's taken confidential information to another competitor. You might very well see the competitor themselves named. There'll be almost certainly some other causes of action as against the individual and also any third parties that are brought into proceedings. I've listed some of them here. So breach of fiduciary duties, particularly with senior employees, breach of the equitable duty of confidence. There may very well be a claim where an employee has been poached for inducing or procuring breaches of contract or fiduciary duties, especially if a competitor's come along and said, come to us, we'll double your salary, and why don't you copy that database in the process? This also might overlap with the stability of the workforce point that Laura's just talked about. There may very well be a case for causing loss by unlawful means and unlawful means conspiracy. It's all very fact specific, but do bear it in mind, because it's important to, as far as possible, plead your claim as comprehensively as you can from the outset. It may be that if there is a breach by a previous employee, he might be a man of straw, but his new employer, who might also be on the hook, may have the means to meet any damages claim and any costs order. And also bear in mind that some of these concurrent causes of action might also have different forms of relief or different measures of damages. Laura, do you want to talk to us about the employment tribunal?
Yeah, absolutely, Helen. And it starts on the same point as you've made of it's all very fact specific, but it's not uncommon to see competing cases. It can often be, it can often be just breach of contract and constructive unfair dismissal in the employment tribunal, but it's also not that uncommon to see a whistleblowing case thrown in. Sometimes discrimination, but perhaps not so much, alongside a loss of aggressive pre-action correspondence on the civil side, possibly an application being made, but if you'd gone, say, for an interim injunction, that's going to be heard before you get to tribunal. So it's more when that doesn't happen that this comes up as an issue. Sometimes it's just used in the background and it's a negotiating tool and no one ever actually wants to pay the court fee. But if the court fee has been paid and matters are progressing and the case has actually been issued and you've got your concurrent tribunal proceedings, then it can be a matter you've got to deal with in terms of who goes first for what reason. Now, if you were just dealing with breach of contract and constructive unfair dismissal case, how long it will take to get to a hearing depends on what tribunal you're in, but in many it's going to be over a year. There's only the odd few where you get heard before that. But if you are dealing with discrimination or whistleblowing complaints, you will have a preliminary hearing in order to determine what the case is about and then set the matter down for directions, possibly another preliminary hearing if there's a preliminary substantive point to be determined. And so you need to know by that point, do you want the tribunal case to go ahead first or do you want it to be stayed? I tend to find people want the tribunal process to be stayed, but that really depends. Excuse me, just bear with me one moment. That usually depends what side you're on, whether you actually want to spend the money of going to a hearing. And remember that in the tribunal, other than in exceptional circumstances, each party pays their own costs, or whether you want to kick this into the long grass. There are guidelines in terms of seeking a stay in the tribunal, but what I would essentially say is it will depend on, is the tribunal case or is the civil action a sham? Or are they both genuine? How quickly are you likely to get to hearing on either? So say if you're at a preliminary hearing on in the employment tribunal, you need to have a good idea of when you might get to trial in the civil action. What level of judge you're going to have, because the tribunal is unlikely to determine factual matters if it's then going to be heard by a High Court judge. Really, even in HHJ, that is probably a persuasive point, but particularly if it's a high court action, that's going to be persuasive because they don't want to have, they don't want to be treading on the toes of facts that a high court judge might need to determine. And also, what is the scope of what each court or tribunal is going to have to determine? Are they actually separate factual matters? Are they matters of credibility that are going to be overlapping, or are there actually similar facts, such as if you've got the constructive unfair dismissal case because the employee is saying, well, actually, you employer were already in breach of contract and therefore you can't hold me to these clauses under the contract that you're trying to. Clearly that's going to be the same in both forums. So all of those factors go into the pot for you to consider, and it will be a matter of timing and a matter of persuading the tribunal, if you're wanting to get the stay from them, that this is proportionate and in the best interest and it's the appropriate place for the matter to be determined. So that's, I can't give you an answer so much as I can say those are the points that you need to be thinking about.
Okay, I'm conscious we've only got about a minute to go, so I'll just whistle through this. First off, back in the civil courts, the initial disclosure is likely to be applicable here. Use it to your advantage, because it may be that initial disclosure comes back from the employee, and all of a sudden the case doesn't look as strong as it was, and you can use it to get out of matters early and at minimal cost. Having said that, disclosure is going to be important, and you might want to reserve the right and budget for amending proceedings after disclosure's happened. Think carefully about the models of disclosure as well, because here you might very well get Model E or more likely Model D against the employee, but that doesn't mean that the same will apply to the employer. I have a case where we've got Model D and Model E against the employee. The employer is doing Model A and Model B. And finally, this could be a topic in and of itself, but just bear in mind when you're preparing any application for an injunction, how you prepare the witness statement, because we've of course got the practice direction on trial witness statements, which now has the statement of best practice. I'm sure you're all really familiar with it. It doesn't apply to witness statements for applications, but follow practice direction 32 and part 32 and practice direction 32. Expect criticism at the application stage if there is non-compliance with part 32. Taking the court through documents, making submissions as to what they show or what inference are or might be drawn from them is a matter of argument. It's not a matter for witness evidence. And the practice direction makes very clear that the costs of non-compliant witness statements or affidavits may be disallowed. And my experience is the court is more likely to exercise that and to express criticism now that we are in the swing of things with using the practice direction when it comes to trial witness statements. So just bear that in mind.
Just to add on that, Helen, it's worth looking at on that all of those points, a very recent case, which is Cheshire Estate and Legal Limited against Blanchfield and others, which was heard this summer as a speedy trial in Manchester before His Honour Judge Beaver, sitting as a judge of the High Court. And that addresses so much of what we've talked about, not in terms of setting any new principles, but a very recent case to look at, but it does also touch upon particularly the point of witness statements, because there, and the particular practice direction, there the claimant has sought to introduce expert witness evidence from a cybersecurity investigator, failed to comply with the practice direction 57 AC, and has sought to introduce them as a lay witness evidence, and the court was extremely critical in that respect, noted the complete disregard in terms of the practice direction, and that had left the claimant vulnerable to costs, and it appears that after subsequent cost hearing the defendant was successful in their application and was awarded, I think they got their 60% of the costs. So that shows you some of the consequences that can follow through and the approaches that judges are taking to that in exactly these sorts of cases.
Thanks, Laura. All right, that brings us to the end of the slideshow. I'm just going to unshare my screen. Thanks everybody for joining us this morning. We've had some questions in the Q&A box, and I've answered as many as I can as we've gone along while Laura's been talking. I think there might be a couple. I will put together an answer for those and come back to you. As we've already said, the slides, the recording and the notes that accompany this talk will come out to you next week. But that just leaves me to say thank you very much, everybody, for attending, and enjoy your Friday and the rest of your weekend.
Thank you, everyone. And I can see there are questions about that last case, so I will attach a copy with what we're sending out for you.
Okay. All right. Thank you very much, everybody.
Have a great Friday.
Good morning.